codified in law that essentially, using the layman's terminology, that a man's home is his castle and he has the right to defend it. So in this case, that was sort of my analysis of this, was that when Mr. Morrison felt as if his home was being invaded, and I don't know at what point exactly he knew it was law enforcement, but the normal natural reaction would have been to seize a gun at 1:30 in the morning and confront the intruder at least long enough to perhaps call law enforcement. I'm sure it was quite a surprise to find out it was law enforcement.
So if you found out that Mr. Michael Morrison called 911 to complain that somebody's breaking in his house and called his daughter to say someone's breaking in the house before he actually knew who was breaking in it, does that support your theory or is it against your theory?
I think that supports my theory.
Would you believe, based upon your knowledge, your reading, your understanding of this case, that Mr. Morrison would have had the right to grab his gun if he even did? I'm not suggesting he did, or waiving any rights of what we're saying, but would he have had the right to grab a gun or a weapon, not knowing who precisely was out there?
Yes.
Why is that?
Because I believe that he felt it's prima facie, it's understood. You can look at 776.032, you'll see that, the protections for individuals who are defending themselves with the reasonable belief that their life is in imminent danger of death or great bodily harm, is profoundly stated. And at 1:30 in the morning, again, I think it is reasonable, perhaps even subjectively reasonable. I think the layman would have assumed that under the circumstances that a person who was breaking into their house was doing that for the purpose of gaining entry into their house. And this is the area of the castle doctrine that protects individuals who take action at that point without even being physically touched.
I think the ultimate crux in this case is going to be assume that Michael Morrison knew at some point that these were police officers, the window was broken by an ex-girlfriend, and that he's now confronted with officers yelling at him to come out. Considering that to be true, do you believe, or do you have an opinion based upon a reasonable belief of the facts and your expertise, your education, experience, whether or not Mr. Morrison would have still been allowed to arm himself against officers who are demanding that he come out?
Yes.
Why?
The badge does not grant any special permission for law enforcement officers. What grants special permission is warrants to be able to enter. And one of the things that he said, and you can hear this, I think, on the telephone, he is demanding to see a warrant. The officers have plenty of time to show him one. When they don't, he should reasonably assume that they don't have one. At that point, he can also reasonably assume that they can't come in his house. So from that perspective, and understanding the fact that they just broke the window, that they were standing inside of his house at the time that this happened, I think he had a reasonable fear that his life was in imminent danger from the intrusion of these people. Two of them happened to be wearing uniforms.
Is it important that he didn't go to the door, the front door, but he went to the back window that was busted out in order to confront officers with a gun at 1:30 in the morning, or guns?
No.
Why not?
I mean, going to the front door, first of all, I don't know what point he heard. He said he was in the restroom, he didn't hear much of what was going on until he was confronted with this loud explosion in the back of the house. But the point is, he could have sat in front of the front door knowing that there were law enforcement officers out there and demanded a warrant, and if they didn't have one, he did not have to let them in. He was completely within his right to do that. So it doesn't matter that he investigated the scene.
Well, if they came in without a warrant, they busted open the door, and in my next hypothetical, they say police, they bang on the door, they bust open the door, they come in without a warrant, and he's sitting there with a gun. Would he have been allowed to shoot?
No, not at that moment. Now, you're assuming this in hindsight, that he would know they didn't have a warrant. I think we have had cases like that where officers have come in without warrants, have been shot, and the defendant has been exonerated. That has happened many times. But he would not be expected to know whether they had a warrant or they didn't. So we have to look at it from the perspective of the defendant at that time. If there's not enough time for an individual to know that a law enforcement officer has a warrant, then they are compelled to comply. But when there is enough time to verify that, and they don't, then it can be assumed that they don't have.
Well, as in this case, he didn't shoot anybody, you know that, right?
Yes,
And if he was there sitting in a chair and they broke through the door, would he have a right to threaten use of deadly force, not to have a warrant or to present it with a warrant? Not shoot, but threaten deadly force.
no. He could demand to see a warrant, and they would be obligated to show him.
So if now put him in the back window and the officers are out there and they're yelling their officers at the back window, the window's now been busted out, does he have the right to threaten if they come in or try to do anything to them to use deadly force, not to allow them in?
I think the time frame, so there's two components in decision-making under stress, and I'm quite sure this is very stressful. One of them is time, the other is criticality. So I think what he had to do was make the best decision based on those two elements. When he had a lot of time, and it was highly critical, he could have afforded them an opportunity, for instance, to say, we do have a warrant. And at that point, legally, he would have been required to not challenge them, certainly with the use of deadly force.
So let's assume officers are now faced, as in this case, with the fact that they made a mistake. Assume they made a mistake, they're there, no warrant, they got the guns, windows busted out. What should the officers have done based upon policies and procedures at that point with allegedly, and I'm not suggesting my client had a gun in his hand at any time, but assume that he even had a gun in his hand and pointed it. What should the officers do?
After having taken inventory of the facts and circumstances, they should have left.
Well, why would they just leave? They allegedly believe that he pointed a gun at them, and why would they just leave? They've got a man who's in the house with a gun who's made threats.
They're trespassing, they're perhaps burglarizing his property. They have no lawful authority to be there, they have no warrant. At that point, they have to undo what they did wrong. And the only way to do that is to comply with his orders to leave.
And do you believe, or do you have an opinion, based upon a reasonable degree of expertise, whether or not they could have cornered off the area, closed it down, and waited for a search warrant or arrest warrant, even at that time of night?
I don't think they would have gotten probable cause for a search warrant, but had they had enough to arrest him, then the answer is yes.
Are the citizens of the state of Florida obligated to submit to excessive force on the part of law enforcement by law?
If they know it's excessive force, the answer is no.
Does every American citizen have the right not only to protect themselves, but also to protect others against the government?
Yes.
Why is that?
It's constitutionally, it's our methodology to prevent against tyranny.
Is it a Second Amendment question?
It is a Second Amendment question.
Did you have to go to law school to study the Second Amendment to know that American citizens have the right to protect themselves against improper government intrusion and excessive force?
No.
Do you have an opinion based upon a reasonable degree of certainty as an expert in this area, whether or not Mr. Morrison did anything unreasonable or unlawful under the circumstance? And if so, what is that opinion?
My opinion is that he did not do anything unreasonable or unlawful. And I'll hold that to what happened on his property, because I don't know, there has never really been a full investigation on what happened with Ms. Mays.
Now, do you believe that the officers in this case created their own exigencies?
I do.
Why is that?
Because they created a circumstance in which they later tried to justify the use of deadly force.
What do you mean by that?
They put themselves intentionally in harm's way without serving the lawful, bona fide law enforcement duty. And then when Mr. Morrison responded to that, they co-responded by shooting him. We see this most often in police work with officers who jump in front of speeding vehicles and then shoot the driver through the windshield rather then going onto the sidewalk and allowing it to pass. It happens quite frequently, and I think most Americans have now seen it enough time on television technology to understand that the smarter thing to do is to take yourself out of harm's way and avoid shooting the driver than to place yourself in front of the vehicle and killing the driver in an effort to stop him. That would be the best example of creating your own exigency, and this was not too far from that.
Do you have any knowledge of whether or not they alleged after the window was broken open, they saw him standing back from the window with his arm out pointing a gun, then another time walking by holding a automatic weapon, and then the third time pointing the gun again? Do you recall that?
Yes.
Now, considering, let's break that down. The first time he points a gun, if you believe that he had every right to do it the first time, do you believe the second time when he allegedly points a gun? I'm not suggesting he did or saying that my client did, but I'm asking you to assume hypothetically that he did, according to the police, the second time points a gun out that window, and then they shot him. Now, it didn't go outside the window, it was inside the kitchen, not extending out through the window. What is your opinion of that then? Would he have a right to do that?
Would he have a right to?
The second
Would they have a right to shoot him? They should not have been there. That's my position. So it would have been, had I had the opportunity to coach them through this, none of this would have happened. They should not have been there, and I have to be very clear about that. The opportunity that they afforded him to perhaps shoot him if he wanted to, which I think is clear that there's no evidence that he did.
Well, let me ask you the alternative. If they reasonably believe that he, on the first occasion, really pointed a gun at them, and they had a belief that they had a right to shoot him, do you have any reason to know or suspect why they didn't shoot him the first time?
I don't know that.
How about let's go to the second time, assuming, arguendo, that they see him, or one of the officers sees him with a flashlight walking around with a pistol down by his side. Do you think at that point they would have had the right to shoot him walking around with a gun inside of his house?
I can't answer that in this way, and the reason is because there's two parts to this. It is a transaction. It's what he's doing, but it's also what they are doing. And I think one of the things that we've missed in some of this conversation is that we're trying to measure things from an objectively reasonable standard, but there is a second standard that gets overlooked, and that's the necessity, that's the need to do it. Something can be objectively reasonable but not necessary. In this case, that would be where I offer my opinion that obviously when somebody points a gun at you, your life is in imminent danger of death or great bodily harm under any given circumstance. But the necessity to use deadly force wasn't there, partly because they shouldn't have been there.
Let me take it another step further. The third time, it's alleged that he pointed it through the window, not pointing it through the window of the gun, but back from the window, and they could see him extending his arm and pointing it. Did they then have a right to shoot him? Because he allegedly would have known from the first and second time that he had a gun and there was police out there.
Did they have a right to shoot?
Yeah.
No, they shouldn't have been there. I don't know how better to say that. They did not have a right to be there pointing guns at him in the first place.
Now, let me take it even one step even further. Let's assume, hypothetically, that the evidence is going to be that Mr. Michael Morrison will say under oath, I never pointed a gun at any of the officers at all, and I was standing there next to louvered doors, and I was going to get a cookie, and I was on the phone talking to my daughter when I was shot through the back this way, as he had his left hand up getting the phone, talking to his daughter, trying to get a cookie with his right hand, and he was shot through the back. Do you believe that it may have been an accidental shooting by the officer, Corporal Matt Armstrong, and now a cover-up?
Objection. I think this goes beyond the scope of what expertise he's even talked about.
Sustained.
Have you ever heard of officers accidentally shooting individuals?
Yes.
Have you seen on...
Same objection, Judge. I mean, I don't even see how this is relevant.
I haven't heard the question. What's the question?
Have you seen accidental misfires of semi-automatic weapons by police officers?
Yes.
Sustained.
Have you heard of officers when you're No, as a firearms expert, do you have an opinion based upon a reasonable degree of expertise as a
Objection,
firearms?
I don't think we ever did anything that he's a firearms expert anyway. And
He testified he was. Now, if the state doesn't recall it, I'll be glad to go back through that again,
Tell me how this is relevant.
because I believe if I ask the following question and follow-up, that the proper way of shooting somebody that you're feeling defensive about, that you're gonna get killed, is to shoot twice, not once. That it's more indicative of one shot as accidental than two purposely to defend themselves. And as a firearms expert, I think he could answer that question.
Sustained.
I object. Please note for the record.
I don't think you have to object.
I don't think so either, but I just want to make sure that the court knows I'm objecting.
I do, thank you. I can tell by your expression, how's that?
Thank you, but the appellate court can't see.
Yes, sure. Sure.
Now, what was so important about seizing Mr. Morrison that night, if you know, based upon your education, training, experience, and your expertise?
I don't think there's anything for it this season.
Would there be, had you heard any information that he would have been a raving maniac running through the neighborhood shooting people if they just packed up and left?
No.
Do you have any knowledge that the community would have been placed in any grave danger at all because he had gun or guns in his house at that time of night?
No.
Now, the fact that they did have a SWAT team out there and a negotiator that was unsuccessful in trying to get him to come out of the house, did any of that information, as I'm now advising you, affect your opinions in this case?
I mean, I'm aware of it. No.
Do you have an opinion based upon your understanding of this matter and your expertise, whether or not the officers should have continued to be ducking down behind a hot tub, pointing a gun for 30 to 45 minutes, out there inside his house over the threshold?
As a tactic?
Yes.
Well, it was a bad tactic. If they thought they would be involved in a gunfight, we know that hot tubs don't stop bullets. But we can reasonably assume that that material is not something that you could rely on to stop a bullet. It's probably better said.
Do the police have a duty to protect?
They may have a moral duty, but they don't have a legal duty.
So if they were trying to protect Miss Leah Mays from Mr. Michael Morrison having a gun inside of his house or guns, did they have an obligation to protect her by waiting there, pointing guns for as long as they did?
If they wanted to protect her, they should have brought her there. But after she was there, at that point, they created, I think, a circumstance in which they now had what is often referred to as a special relationship with her. They introduced her as a state-created danger, introduced her to danger, and then did have an obligation to protect her.
Hold on 1 second on that, please. So, sir, let's go back, and I want to break it down a little bit, because maybe I've gone a little bit fast. But when the officers, when I say officers, I'm referring to Corporal Matt Armstrong and Officer Dale Kelly, or even potentially Sergeant Rod Erdman, who was there from Holly Hills. When they went to the door and and knocked on the door, were they in the lawful execution of their legal duty based upon your training, education, experience as an expert in this area?
If they have the right to conduct an investigation, it was unreasonable to do it then in that way, but they were in the middle of an investigation. Knocking on somebody's door is not legal.
Did they have, when they walked through the chain link fence, whether they broke the lock open or just opened the chain link gate, and they walked through that down the path in the curtilage area of this house at 1:30 at night, were they in the lawful execution of their legal duty in walking down that path as you saw in the pictures?
At that point, no, because I think the reason is they were no longer conducting an investigation. They were starting to facilitate the beginning of all of the other cascading events that happened. And I think at that point, they exceeded their authority after he refused to come to the door or didn't hear them at the door. The investigation was over for that night.
When Leah Mays jumped over the wooden fence and opened the fence for them to come through, and they walked further on through another gated area down that path in the curtilage area, was the officer, again, Corporal Matt Armstrong and Officer Dale Kelly, in the lawful execution of their legal duty?
No.
When they went around the side of the building with Miss Mays and opened up those sliding doors to allow access into the house, not just being on the curtilage, but into the house, were they in the lawful execution of their legal duty?
No.
When they got into the inside interior of the house where the window is, and Miss Mays broke open the window and they grabbed a gun and crouched down, were they in the lawful execution of their legal duty then?
No.
After the window was...
I don't understand we've already addressed this, but just for the record, for my objection, this is all legal conclusion, and I think this would invade the province of a jury. And I know we've addressed this, we'll talk about this later, but I just wanted to note that objection for the record.
An expert is allowed to make expert opinions in areas of their expertise, even if it is where a jury can make an ultimate decision and not agree with an expert. Because the jury instructions is that they can believe what an expert says, some of it or all of it or none of it, in making their own conclusions and opinions.
Okay, I guess the question is whether or not an expert witness can give testimony and reach conclusions with regard to solely legal issues that are the province of the court. And I think that's an issue here, and I believe I heard you to say that you were prepared to address that at the appropriate time. So, and I'm going to give you that opportunity. So I understand the nature of the objection, and I'll defer, I guess, at this point in time until that argument occurs. Okay?
Thank you. I have one or two more questions, then I'm done, Judge.
All right,
Just trying to
thank
sum
you.
it up.
Go ahead.
At some point during the course of this entire event was when the Officer Corporal Matt Armstrong shot Mr. Michael John Morrison through the back. Was he in the lawful force and scope, or were they in the lawful execution of their legal duty when he was shot?
Perhaps I should say that was objectively unreasonable, so I can stick with procedures and methods that law enforcement officers would be reasonably expected to use, rather than giving you a straight yes and have it interpreted in a way that I don't intend.
Okay, so let's go back and just say, was it objectively reasonable for them to walk through the fence?
It was objectively unreasonable for them to do that.
Was it objectively unreasonable for them to walk through the wooden fence?
It was objectively unreasonable for them to do that as well.
And for them to allow Ms. Mays and them to go into the building and crouch down with guns, was that objectively unreasonable?
It was objectively unreasonable.
I have no further questions, I tend to believe this. Thank you.
Cross-examination.
Sir? All right, just a few questions. Do you agree you can make an arrest without a warrant?
Yes, in cases.
Well, in fact, probably a vast majority of arrests are warrantless arrests.
Objection calls for speculation, surmise, and conjecture as to vast majorities. It's overly broad and vague.
Sir, give me an answer. Would you say most arrests are warrantless arrests?
Of all the arrests or arrests that occur in somebody's house?
All arrests.
All arrests, I would say, I don't know the answer to this, but my gut tells me that yes, the answer is they're mostly warrantless.
Well, you've been a police officer for 30 years, you said, something like that. Not quite, I guess.
20.
28, so almost 30. Would you say, what percentage of cases that you've had do you think were warrantless without the warrant?
arrest. If I observe a crime versus somebody tells me about a crime versus after I
All
enter a
arrests.
house.
All right.
If you
Objection,
told-
Your Honor, he's got a right to finish the statement before the state talks on top of him.
Let them go ahead and finish the answer.
So the questions for all arrests.
I don't want to skew the point of my answer by collectively grouping things into categories that are somewhat unrelated. To answer your question, as I would in the classroom, yes, most arrests in totality, not most home entry arrests, but all arrests can combine together. I would say the great majority of them are without a warrant.
Okay. In fact, I mean, I know that you're saying that a lot of in-home arrests have a warrant, but there are situations where you can enter a home without a warrant, correct?
There are situations, yes.
And so there are certain crimes you can make warrantless arrests on, correct?
Yes.
And domestic violence is a crime you can make a warrantless arrest.
In a home?
Just in general, you can
In
make.
general, yes, you can.
Right. And, this was Roski coming straight out if he thinks I'm misleading, but just, going along the lines. And another point that I wanted to bring up is you said that as far as jurisdiction goes, this case starts in Daytona, goes to Holly Hill. We're in agreement on that.
Yes.
You said that rather than getting Holly Hill involved, they should have got VCSO, Volusia County Sheriff's Office involved. If it's in Holly Hill, why does that matter?
Well, there are issues like, for instance, mutual aid agreements that I'm not sure if they exist or not, but it tends to give more, those are generally granted by the sheriff. The sheriff is the one that says you may exceed your corporate jurisdictional boundaries and do police work in other areas of our county. And I'm not sure if that exists or not. I think maybe you and I discussed it, but I don't remember the answer to it. It's just always safer to get the constitutional officer to prevent jurisdictional problems. And I think that's what the question was.
Let me just ask you this, just because, I mean, Mr. Bross can discuss it with you later, but there is a mutual aid agreement. I guess you haven't read it.
I seem to remember that. It slipped my mind. I was going fuzzy on it.
Well, as far as you're aware today, is there anything you can point to today that would say it's inappropriate for Daytona to have gone to Holly Hill rather than VCSO?
I don't think it was the best choice, and I think it may have been more important that Holly Hill investigated the cause of the arrest, and without a warrant, that's hard to do.
Well, I'm talking jurisdiction-wise. Why does it matter? I'm still trying to get back. You said you would have gone with the sheriff over Holly Hill.
Right.
Why does that matter?
I don't think it matters that much.
Why would it matter at all?
I told you, because I think a constitutional officer is the one that, for instance, when warrants are served, this is who essentially is responsible for the service of the warrant. The sheriff is the constitutional officer of that county.
If it's in Holly Hill,
Your Honor, objection again. He was finishing the statement when he was cut off.
is there anything else that I cut you off on?
As far as what?
I don't know. You said
What's
you cut you off. I don't
what's
think I
previous?
did.
The crime occurred in Daytona. It occurred in a different city limit. The alleged arrest was about to be made, according to what the officers thought they were there to do originally, in a different municipal jurisdiction.
And Holly Hill has jurisdiction over that area.
Right.
Right, so I'm still trying to figure out why it's inappropriate for them to go with Holly Hill.
Well, again, it does look like the Confederate may be involved. I'm not willing to go on record saying that's what happened, but it certainly gives the illusion of that when you take a person in that area who is a police officer for the strict purpose of making an arrest, you have to question the motive of the officer who solicits help or the confederacy of another officer to carry out a function he can't do by himself.
Why would it have been, so if they go with the Volusia County Sheriff's Office, that would have been a Confederate?
No, I think it would have been the same.
So would you agree that it doesn't, it matters none whatsoever if they go to VCSO or Holly Hill?
Yeah, I don't know all the nuances of the mutual aid agreement. I can't answer the question fully, but I would tell you that from a policy procedures perspective, if this were written in the policy, my recommendation would say to get the county officer.
And I'm still, you keep saying that, but what's the reason for it?
That's what I was trained to do. That's my experience tells me that that's what most agencies do. We don't generally rely on other municipal because of the constitutional strength of the sheriff's office.
What's the constitutional, I mean, if they both have jurisdiction, why does it matter?
Objection, asked and answered, argumentative.
I've got an answer.
Go ahead, you can answer the question, sir.
Yeah, again, I don't know all the nuances as to my answer. I know it's the accepted practice, if you would.
Because you told Mr. Bross that VCSO over Holly Hill, so would you just say that was a guess and maybe not the answer you should have given?
No, I would say it's not the answer I should have given. It's the accepted practice. It's more what you see in my line of work is that we turn to the county office for the facilitation of arrests outside of municipalities.
Are you familiar with that type of policy in Volusia County?
I'm not.
So could Volusia County's policies be different than Tallahassee's policies or other counties?
I expect they are.
So when you're answering the questions, the reason I'm going over this is when you're answering these questions, are you just giving these generalized answers without having information about what actually goes on here in Volusia County?
I don't think we got into this. I would have researched it a little bit more and been more prepared to answer your question. So if I seem like I'm hedging, I am, and it's just because I know what the more common procedure is. And I would like to give you a better answer as to perhaps why majority opinion does that. And I'm sure there must be a reason. But jurisdictionally speaking, what I know about jurisdiction is, of course, that Holly Hills has jurisdiction in Holly Hills.
All right. And I believe it's just Holly Hill, but it doesn't matter. I mean,
Sorry.
and I don't mean anything by that. Going back to Mr. Ross asked me a line of questioning about the information that the police had on Leah Mays and what they could have done to see if she actually lived in the house. I want to ask you a few questions about that. But would you agree that if the police officers want to enter a home, there's multiple reasons they can enter without a warrant?
Yes,
Just in general. And one of those can be consent, correct?
that's true.
And it's not just the registered homeowner is not the only person who gives consent, correct?
That's right.
Who else can give consent?
Family members,
All right, we'll say, who else?
somebody that reasonably appears to be in control of the home,
Co-inhabitants?
don't happen.
Anybody with common authority over a home?
Well, now you're getting into the question, which is who has common authority, and that would go back. The onus of that would be on the officer to determine who had common.
Well, I'm just talking about in general.
If you already knew that, they had.
Well, not that
Objection, Your Honor.
specific.
He's got the right to answer his questions. Cut off
You
again.
finish your answer, sir. Yes, sir.
What was the question?
Mr. Ross is interrupting, but I'm saying
Well,
it's
keep
not
going.
over, I'm not asking you case-specific questions, I'm saying in general, anyone with common authority can consent to the police officers to come into a home, correct?
In hindsight, if you knew that they had common authority of the home, then yes, they could consent.
And as far as, what the police officers could do to determine common authority, Mr. Bross had asked you questions like, check the property appraisers, check the driver's license for David, check to see mail, things like that, correct?
Yes.
Well, would you agree that, one, the property appraiser is gonna have the homeowner, correct?
Yes.
That's what a property appraiser is.
Yes.
They have- So it could be the homeowner, in some cases, might not even have common authority, correct?
That's true.
In a rental house. So that certainly wouldn't be conclusive, because it could be, a husband can own a house and not have the wife's name on it, or, you could have a parent own the house of a child. So the homeowner, and often, is not the one with the authority of the house, correct?
Right.
As far as driver's license and David, you've done this for a long time. Would you agree that a lot of people don't update their driver's license?
Don't update it?
Correct.
I think that happens, yes.
And not to be offensive to anybody, but would you agree that there's certain classes of people tend to move around more than others?
Yes.
And were you aware that I came out earlier today that Leah Mays was apparently a dancer or a stripper, whatever you want to call her, at a local gentleman's club?
I have heard that. I don't know if that's true.
And it's legal, not to be offensive, but would you agree that in your experience that people in that type of line of work move around a lot?
We don't have those clothes in the county.
You don't have, you don't have those clothes?
Yeah, they're forbidden, so I don't deal with that element so much.
And people can have two addresses, correct?
Yes.
In fact, in Florida, you've heard the term snowbirds,
Yeah,
and I mean, a lot of the people who own homes down here have a different address, correct?
that's right.
And in fact, earlier today, a witness testified for the defense that Leah Mays was living at this other address that I guess she visited, I think it's 408 South Ridgewood.
Yes.
And she apparently was not, according to this witness, receiving mail at that address. Were you aware of that?
I didn't know that.
According to the defense's own witness, and Mr. Ross can correct me if I'm saying anything that's not appropriate, but she didn't have food at 408 address. There was no kitchen. Were you aware of that?
I don't know anything about that.
And she had none of her own furniture there. Apparently, the only items that belonged to her were some clothing at this 408 address.
Okay.
So what I'm getting at is, say the police, for the sake of argument, had checked at David, we certainly don't know if that would have been registered to either one of these addresses, correct?
That's right.
So there's scenarios where maybe the officers can't look up anything to confirm somebody lives at an address,
Agreed.
right? And in this case, Ms. Mays, I guess, had told the police that she had animals at this home. Were you aware of that?
She had a cat, I remember reading it.
At Mr. Morrison's home?
Yes.
And in fact, I believe she did have a cat at the home, correct?
I don't know if that's true.
And if she gives them descriptions of, the home and, that she has belongings, and in fact, they do find belongings in that home, do you think that would lend credence to the police officers that she actually was a co-inhabitant of this home?
I don't know if they could identify belongings as being hers. You need something more significant, I think, that was very specifically identifiable to her.
Well, if driver's licenses aren't always accurate, property appraisers aren't always accurate, mail isn't always indicative of where you live, what else, what can the police officers do? What should they do 100% of the time to confirm someone lives at an address?
What we use is what's known as the totality of circumstances.
Right.
So there's no single piece of evidence that can say absolutely that somebody lives there. But there is a responsibility on the part of the police officers. The default is she doesn't live there without proof. That's the default. So the question is not to disprove what she's saying. It is to prove what she's saying. And what she's saying is, I live there, and it begins at ground zero. And then you work your way up through the totality of the circumstances. And what I found in this case is there was no circumstance, with the exception of what she said, that she lived there. And that's not a high enough standard. I would submit to you that a locksmith has a higher standard than that before they allow you into your car. They want to check your ID. Or before they let you into a house. I've had that experience with locksmiths before, and I know that's a common procedure. I would anticipate a police officer would have a higher standard than that.
Well, we agree. I mean, there were connections to her to the house. Like, she knew Michael Morrison, for one. And she claimed she had been dating Michael Morrison, correct?
Yes.
It's not uncommon girlfriends live with their boyfriends, or at least stay over there.
Right.
And she can give the police description of the home, so you'd think the police would know she's been there before, correct?
I think one of them says that they worked a case there previously or something, where she broke something 2 weeks earlier, as I recall.
Do you agree the police had evidence that she at least had been to this home before?
Sure.
And she gave evidence, she told the police she had belongings there. I guess I'm getting at, what else did the police have done that night to confirm she lived there?
I don't think they will let the mailman in. I mean, he goes there every day. There has to be something that indicates that she lives there. That's what the officer's trying to determine, not whether or not she's friends with Michael Morrison or has a relationship of any degree. That's not the job of law enforcement. I think they knew that, actually. I think they felt comfortable, and I felt comfortable reviewing the case, that these were not two people that just met. That being said, probably the most important right we have in America is property rights, and we have an entire government built up around protecting that. And I'm speaking now as someone who teaches law enforcement officers about these things in terms of violating somebody's private property. We would demand in training that officers learn and apply a more certain technique to assure that before they help to facilitate someone to get into a private property, that they could say more reasonably than not, at the very minimalist standard, that she lived there. And there's no evidence at all. There's nothing that's reasonable at the minimalist standard that she lived there. Nothing. And so this is what struck me so unusual about the case, is that the officers, and though your points are well taken, there's not a single thing they could have done that would have amounted to proof necessarily. But the totality of circumstances, they don't even pale, they don't exist. And they help her, they help facilitate her get into the home.
And what you just said was something I wanted to ask about. I mean, in your opinion, is there any evidence that you think, realistically could have existed that would have rose to your opinion's level that she lived there?
Well, yes, I think the totality of circumstances, if she had a car that was there, if she did have a driver's license, if there was mail there with her name, and those things started to add up, certainly 1:30 in the morning, this is not the right time to conduct this, and that's a whole separate issue that we talked about. But if they are going to do this at 1:30 in the morning, the onus remains on law enforcement. That's the important thing to remember. The onus remains on law enforcement because they are about to be party to something that could be illegal and certainly is a high liability. So we would instruct officers that there's a due diligence associated with this kind of activity. And if you can't muster the information to demonstrate within a reasonable degree of certainty that somebody lives in a place, you can't help them break into it. You just can't do it.
Well, and, you can go back to your examples. I mean, I can park a car at a house I don't live at, and there's pretty obvious, correct?
I'm not saying that the cops would have been correct. I'm saying that they would have had better ground to stand on. Had they done this, we could have said it was in good faith. This is a case that was not in good faith.
Well, would you think that if her car was there, then they would have been okay using her consent?
Yeah, I think I answered that. There's no one absolute thing that you could say assures you that she lived there, but there is a totality of circumstances. I think that would have been helpful to have her have a car there.
If their driver's license said that address, would that have been enough?
Yes.
So you think just driver's license, then that equals consent?
No, you're pigeonholing me into a single item. There's a totality of circumstances. Here's what I know from reviewing the cases. They had nothing. So aside from all the single items that you're tossing at me as evidence or proof, they had nothing but her word.
Well, they had, you keep saying they had nothing. I mean, they did have, they knew, as you said earlier, she had a connection to the house and to Mr. Morrison.
What does that mean?
Well, I mean, that's something at least. I mean, you're going on the totality. I mean, it's not like she just picked a random house and she was like, I think these are rich people, I'm gonna see if I can break in. You knew she had a connection to the house. That's something, correct?
No, in terms of ownership or the ability to declare it her property. That's
Well,
no,
would-
that's
would-
no the connection. I have a connection to thousands of people, and I've been to their houses. I cannot go in their house.
Well, I think would you agree when you're talking about the totality of the circumstances, as you said, that they knew there was or they had a suspicion of a boyfriend-girlfriend relationship
Yes.
of Mr. Morrison. So that would trump friend, I mean, correct? As far as someone, it's more likely a boyfriend and girlfriend live together than friends live together. Not that they're mutually exclusive.
I cannot say that, especially after talking to Mr. Morrison. I'm not sure she was the only girl in his life.
Well, maybe I shouldn't say boyfriend, girlfriend, but whatever relationship you want to, they weren't exclusive, but they were something going on between them. The police knew that at least, correct?
Well, the point I just made, I think, is that every girl that he has a relationship with, providing there are more than one, I don't think can claim his house as their own.
And I'm not saying that they can't. I was going back with, you said, what the police have to look at the totality of the circumstance, and you're saying there's nothing whatsoever. I mean, there are some things, you're just saying it doesn't rise to that totality level.
Well, I mean, you have to operationalize the term evidence. Their relationship is not evidence of ownership, is what I'm trying to tell you. That's sort of satellite to the issue. Evidence would be her name is on a driver's license, her name is on a piece of mail, her name is on the property appraiser's list. That's evidence. I mean, that's something that you can hold up literally in court and say, I was operating on good faith. I reasonably believe that she lived there because of these circumstances. And that's what I'm saying there's nothing of.
Well, let's even go back earlier in the night. The police responded to this 408 South Ridgewood apartment. I mean, even looking at that, the police, I mean, what evidence say that she's doing the same thing they're trying to get in. They're saying that's where she lived, and I believe that is where she lived, but as far as we know, her driver's license wasn't registered there. She was by defense witness, she didn't have mail there. Would you agree that, I mean, you're in the same scenario where you don't have any physical evidence of her living at that address either?
For whatever reason, you just said you believe she lived there, I do too.
Right. Well, the defense witness even said he was renting it to her, I guess, for $60 a week. He said she lived there on and off, I guess. You know, he didn't know where she put her head, but it sounded like she got around to different places. But just for the sake of argument, I mean, there's really no physical evidence of that either.
Was her name on the lease? I don't know.
Yeah, well, that I don't want to speak out of turn, but I don't think there was a lease. I think it was just, I think she was a stripper at his club.
Okay, well, you're asking a police officer, that's what I would be looking for, to say within a degree of certainty that she lived there.
Right. Oh, I'll move on from those line of questions. I mean, you've talked a lot about, you know, this is what the police policy is, this is what the police policy, I write police policy, all of that. I mean, not to be offensive, but you agree, police policy doesn't equal legal. I mean, that's not the case, you know, it's not like I can bring in a police policy to the judge and say, you know, this search warrant was valid because the police policy says it was, correct?
Right, it speaks to procedure, it doesn't speak to legality.
And I hope it's not the case, but in theory, the police policy could be illegal. I mean, they could have a police,
Illegal?
well, you could have police policy that, you know, I can't think of an example of why I tried it with this, but police policy could be to do something that's illegal. Like you could have police policy to never knock on doors, correct?
I haven't seen that, but,
Yeah, wouldn't be smart to, but you could, right?
yeah, I don't generally see patently illegal policies. I don't know that I can recall, I can imagine one, but I don't think I've ever seen it.
And what I'm getting at is back to, you know, a lawyer and a judge over a police officer. And I have a lot of respect for police officers, and I don't mean to by any means say anything negative about police. I mean, I couldn't imagine doing their job. So I don't mean to be offensive that way. But, you know, if I want to prove the law, if there's a motion to suppress, I have to bring in case law or legislative law. I cannot bring in police policy and present it to a judge to say, this should be, you know, this was a legal search because police policy says it, so, correct?
Objection, Your Honor, calls for an expertise beyond the expert opinion of this witness, as he already said, is not a lawyer, didn't go to law school, not a judge, and therefore it calls for a legal opinion, not an opinion from this expert.
That kind of sums up my argument with him providing a legal opinion.
Okay, well, I'm going to permit the question, overrule the objection to the extent that it does get into some questions that the witness did address in direct examination, but we are starting to get a little cumulative. So would you restate the question, please?
Would you agree that police policy is not binding on the court? How about that?
I think it informs the court, but it's not binding, right?
So it has nothing to do with, the police policy doesn't change the law.
It can. It can change the application of the law. In other words, for instance, this whole issue of authority is a legal question, whether someone has authority, but that's a regression. You don't start with the use of force. You work backwards until you find out that the officer has the authority to use force. And so if the officer is using procedures without authority, it is going to change the lawful application and the allowance of what the officer is able to do. That's the important thing.
I'll get past this pretty quick, but the point I'm trying to get in, let's say, for example, with the common authority. So we agree if you have common authority, you can consent to a house. There's Supreme Court cases, there's tons of them that talk about common authority. If the Holly Hill Police Department's procedure says before you can use consent to enter a home without a warrant, you must do X, Y, Z, and you must check driver's license, check property appraiser, check to see if there's mail in there. If that's the police procedure, if the police don't do it, it doesn't change the Supreme Court law. That's just, maybe the officer can get reprimanded, but it has no effect on the law whatsoever.
Objection, compound question.
Sustained.
The fact that the police procedure doesn't have an effect on Supreme Court law or any other, it doesn't change the legislative law.
That's not true either. Supreme Court law oftentimes gives it a civil realm, and I think police procedure has had a profound effect on the way the Supreme Court abuse things. I mean, most abuse of force case law is civil in nature, and the Supreme Court has weighed in on the procedures of the officers under given sets of circumstances, not the legal issues, but how law enforcement conducted themselves under the set of circumstances, like Tennessee versus Garner was really more of a civil case. It was shooting, clean films was allowed all throughout the South for sure. And it informed the Supreme Court that we perhaps need a change in law because of police procedures. So I think you're not asking me the right question.
Then let me rephrase it, because we're in a criminal court, and I'll admit I'm ignorant of civil. But as far as criminal law, then, we're limited to criminal law, police procedure, what the police officer's policies are, don't change what a warrant requirement would be. What these standards that the Supreme Court has laid out for not going to announce, warrant requirements, that type of thing.
It's very related. Probable cause to get a warrant would require proper police procedures. I think you agree with that.
Maybe we're just being around the bush, but I guess, if I'm talking, the point I'm getting at is, if Holly Hill, say they get, some out there police officer, and he wants to make up all kinds of police procedure, it cannot change the legislative law or the case law, like, or in the common law. It doesn't change that.
It informs it. I don't know what you mean by change, but for sure, law looks at police procedures. I would submit to you that most, I don't know if it's most, but say a significant amount of legislation comes from things that have happened. And the things that happen that you observe are the procedures. So it is extraordinarily, influencing what becomes law. We see things, especially when we see things go wrong. And that's why I think our jobs are so difficult, because things change so rapidly as a result of police procedure, which then change the legal perspective, the legislative call for change, and ultimately the question of what is allowed, I suppose, by the police.
We're going to sort of, so I'll just move on.
I might not understand your question.
That's fine. Let's talk about, what Ms. Ross had gone through, the different steps in this case, and what you thought was legal or not. I just want to make sure I'm clear. When the police, when Mr. Kelly, Officer Kelly, picked up Liam Mays, brings him to Michael Morrison's house, you agreed perfectly legal, no crimes being broken, correct?